Justice McLean's orders, in which he specifically preserved their right to continue to peacefully assemble. And he did that in the middle of this demonstration. So those two things are not anywhere found in any of the previous case law, and that's why I suspect the judge has indicated right at the end that this is an unprecedented situation. Canadians have been, historically, we've been prepared to trade freedoms for security. We've done it over and over and over again. We did it to the Italian Canadians. We did it to the Japanese Canadians. We did it to those who were arrested without any rights in the War Measures Act in 1970. We've done it over and over again. And every time we wait a generation or two and then we apologize to those people. So my hope is that we won't be apologizing for anything in this circumstance. Perhaps we can apologize to the people whose bank accounts were frozen. Perhaps we can apologize to the people who were arrested under an Emergency Measures Act that should never have been invoked.
It's unusual, but I was talking to people explaining that there are an enormous amount of evidence in this case, and there are 7 charges, at least with respect to my client, including aiding and abetting, principal, counselling. So there's several layers of legal arguments to be made in this file. So in that sense, it's unusual to be so long in closing, but it's reasonable with the amount of work and evidence we have. I think that the Crown's office sees it as an important case to debate, and let's put the resources into that. It's difficult for a person to put together those type of resources to properly defend themselves against a whole government, essentially. So it has some important issues too with respect to protesters' rights, how far it goes into the rights as opposed to criminal behavior and so on. So